I think Divyam,
Hello everyone, this is Dr. Divyam Goswami, and with my dear friend and colleague Dr. Bhavya Bhansali, we are hosting this DiGo Talks on forensic psychiatry, comparing the paradigms between India and Australia. And we have our guest with us, Dr. Andrew Wilson. He is a forensic psychiatry advanced trainee from Sydney, Australia. Welcome to DiGo Talks.
thanks very much, Divyam.
Yeah, so tell us something more about you, Dr. Wilson.
So look, I'm a forensic advanced trainee, like you said. I'm of Anglo-Indian background, so my mum is from Ujjain in Madhya Pradesh and came to Australia via Uganda, actually in the 1970s. She came here in 1972. My dad's of settler and convict descent from the British Isles, and I was born and raised in New South Wales. I did undergraduate medicine in Queensland before doing an internship and 2 years as an unaccredited orthopedic surgery trainee in Queensland. And then I decided to have a career change and came back to New South Wales, where my family are. And I took on a position as a registrar with the Royal Australian and New Zealand College of Psychiatrists. I'm in my penultimate year of training, and I began subspecialty training in forensic psychiatry in February of this year. I did a Masters of Surgery through the University of Sydney as part of my orthopedic work, and I'm currently doing a Masters of Forensic Mental Health through the University of New South Wales associated with my advanced training. I really enjoy speaking. I'm very passionate about psychiatry, and I lecture to medical students where I can. By no means an expert in Australian forensic psychiatry, but what I can do is provide some understanding of the structure of the New South Wales jurisdiction of Australian forensic psychiatry. And I should also say that everything that I say in this podcast is my own opinion, and I'm not speaking on behalf of New South Wales Health or my employer, which is Justice Health and Forensic Mental Health Network. I'm also pleased to be here.
Nice to hear that, Andrew. So we would like to begin our talk by, I would like to ask you uh, at the onset itself that what does, what is the regulatory framework that you have in place in Australia that governs the admissions, the rehabilitation, the treatment in psychiatric setup? Like here in India, we have something called a Mental Health Care Act 2017, and most of the things are being governed by that regulation. So what is it in Australia?
Yeah, so look, India is technically a confederation of states, but Australia certainly is a federation of states. And we were federated on the 1st of January 1901, which means that we have 8 distinct jurisdictions in Australia when it comes to psychiatry and forensic psychiatry, and each maintains their own regulatory framework. I work in the New South Wales jurisdiction, so most of my knowledge is based around where I work. In New South Wales, then, there are 2 major pieces of mental health legislation. There's the Civil Mental Health Act 2007, New South Wales, and there's the Forensic Mental Health and Cognitive Impairment Forensic Provisions Act 2020, and that's the forensic piece of legislation. So if we go through both, the mental health legislation governing civil mental health is the Mental Health Act 2007, and that governs the involuntary and voluntary care of patients in inpatient settings and the community. It allows for emergency involuntary admissions for those who are assessed to be mentally disordered and mentally ill, which are 2 really important terms. So under this civil legislation, mentally ill patients are not those with a diagnosed mental illness necessarily. They're patients that suffer from delusions, hallucinations, serious disorders of thought form, severe disturbances of mood, or sustained and irrational behavior that kind of indicate one of those other specifiers. A mentally ill person does not necessarily mean that they have a diagnosed mental illness, which is important for episodes like first episode of psychosis, where patients don't yet have a diagnosis of, say, schizophrenia or bipolar affective disorder with psychotic features. But because they fit the specifiers that I outlined earlier, involuntary admission is possible for those patients. Mentally disordered patients is a different kettle of fish. And this is where the patient's behaviour is so irrational as to justify temporary care, control, or protection involuntarily to protect the patient or those around them from serious bodily harm. And the important specifier here is serious bodily harm. There's a significantly greater risk threshold with detaining a mentally disordered person than a mentally ill patient. Mentally disordered detentions they're a time limited kind of specifier, and you can't be detained for more than 3 continuous working days. So that excludes weekends and public holidays. I guess when we approach the Civil Mental Health Act, what we need to consider, or what clinicians consider when using the Act, is the least restrictive form of safe and effective care. Now, that's very important. It provides a boundary or a limit to involuntary care in New South Wales. For example, if someone is remanded for treatment in a mental health facility, it means that once an inpatient admission is no longer considered the least restrictive form of care that would be safe, then a patient needs to be released from involuntary detention in the facility and potentially back into the community. One of the other things that allows clinicians to tolerate risk and transition people out of institutional settings is a construct known as community treatment orders. And these govern involuntary care in the community and allow that transition to take place. The Mental Health and Cognitive Impairment Forensic Provisions Act 2020, very long name, that's like the name suggests, the forensic arm of mental health legislation in New South Wales. It's the interface, the nexus between mental health care and the criminal justice system, essentially. Now, that act is slightly different. As a forensic psychiatry trainee and future as a forensic psychiatrist, that's the act that I most commonly encounter. It does have slightly different definitions. So, as per the name, it discusses a mental health impairment. Now, that is a disturbance of thought, of mood, and of volition that is clinically significant for diagnostic purposes. And that's an important specifier because it puts an emphasis on diagnostic certainty when enforcing the act. And these impairments must impair emotional well-being, behaviour, and judgment. It's important also to consider that the Mental Health and Cognitive Impairment Forensic Provisions Act specifies that these disturbances or impairments cannot be due purely to a substance use disorder or the intoxication of a substance. And that's important and very topical in Australia, for example, where substance use, particularly methamphetamine use, 1.6 million people in Australia, or 7% of the population, will have used methamphetamine at some point during their lifetime. And over 200,000 Australians, or about 1%, slightly under 1% of the population, will have used methamphetamine in the last 12 months. So substance use disorders, which have a relative prevalence in Australia, it's very important that the Mental Health and Cognitive Impairment Forensic Provisions Act actually specifies that these impairments are away from those substance use disorders. Now, we've discussed mental health impairment, but the second part of that title is the cognitive impairment. Now, that's defined as an ongoing impairment in adaptive functioning, reasoning, judgment, learning, and memory. These are either acquired or they can be inherent. They can result from damage or dysfunction to a person's brain and mind, and that might include conditions such as a head injury, resulting in a traumatic brain injury, a substance use disorder, which is also related to an acquired brain injury, or even an inherent condition like a genetic disorder or an intellectual disability. So the Mental Health and Cognitive Impairment Forensics Provision Act essentially provides guidance on the diversion of summary offences where it's more appropriate at the local court level to deal with people through the mental health system rather than the criminal justice system per se, to provide pathways for the assessment of mentally ill and mentally disordered patients who are seen in courts and transferred to hospitals. So the nexus between, therefore, the criminal justice system and mentally ill patients. It also sets out, as we'll discuss later, the defence of mental health and cognitive impairment in higher courts, including the special verdict of act proven and not criminally responsible, which is APNCR. The Act also sets out the standards of fitness to stand trial to ensure fair criminal proceedings, and we will, I'm sure, discuss that later in this presentation. And also, the Act importantly defines forensic patients, correctional patients, and determines their treatment essentially in the mental health system. Now, the last thing to say about these two acts is that both the Mental Health Act 2007, so the Civil Act, and the Mental Health and Cognitive Impairment Forensic Provisions Act 2020, they're both governed or both provided oversight by the Mental Health Review Tribunal, the Forensic Division and the Civil Division. Now, the Mental Health Review Tribunal is a very important part of our mental health legislation and administration here in New South Wales. It's a quasi-judicial administrative tribunal rather than a court per se, and it meets at usually 6-month intervals in the forensic system, but essentially can be flexible with when it needs to meet. And it puts together a panel of a legal preside, a psychiatrist, a member of the community, and an allied health professional to determine methods of providing the least restrictive forms of safe and effective care for both civil and forensic patients. And we'll discuss a bit more about the forensic division of the Mental Health Review Tribunal, I think, as we go through this discussion. So that's a brief overview of legislation, state-based legislation in New South Wales, which does differ across the jurisdictions in Australia.
Yeah, so it is Mental Health Act 2007 and Mental Health and Forensic Provisions Act 2020, isn't it?
That's right. Yes, that's right.
Yes, so going down deep into the specifics of this act, I would like to ask that what would be the procedure of supported admission and what is the concept of the decision-making capacity or the general capacity, because here in India we call it the general capacity, that is, when a mentally ill person is not able to decide for himself or herself regarding treatment decisions or regarding the decisions related to admission and discharge. So, what are the provisions specifically related to this?
So it's very interesting that you raised this, Divyam, and it's actually a topical discussion in Australian mental health legislation and reform at the moment. So there are states, there are jurisdictions in Australia, and the ones that I can think of are Queensland, Western Australia, South Australia, and Tasmania, that actually do have capacity-based mental health legislation. And it sounds like they follow something closer to the Mental Health Care Act in 2017 in India. New South Wales, though, is actually not a capacity-based legislation. So decisions regarding involuntary admission are actually based off risks and assessments of harm both to patients and to society in general. So it's actually not a capacity-based assessment per se.
Yes, so again, I would like to emphasize for our audience that we have, province-based or state-based regulatory laws in Australia, while in India we have a single Mental Health Care Act 2017, by which almost all the states follow this. And I think that is the reason why this is different in New South Wales and it is different in Queensland and other parts of Australia, isn't it?
That's right. Yeah. Look, in terms of the assessment of capacity, um, you know, I mean, discussing more generally, even in civil settings, psychiatrists can be involved to assess capacity. I mean, there are three core principles that apply across all jurisdictions when it comes to capacity, and this is capacity to make, medical decisions. We in Australia, across all jurisdictions, believe that capacity is presumed to be present for all adults. That capacity is decision specific, and an individual may have capacity to make decisions regarding certain items of questions, but may lack capacity to make decisions about others. But the capacity is time limited and therefore may fluctuate over time. And we'll talk about that when we talk about fitness later on. We actually think that capacity assessments are the remit of all doctors and not just psychiatrists. So, for example, an orthopedic surgeon who is consenting a patient for or performing an informed consent for a patient seeking a hip replacement, well, they actually need to assess that patient's capacity during the consenting process. In New South Wales, the New South Wales Capacity Toolkit governs capacity assessments, and it's quite an well, I consider it quite an easy kind of toolkit to use for medical professionals when discussing informed consent. Basically, and you may, cover this in involuntary admissions for psychiatric purposes in India, but in Australia, generally when it comes to medical decision making, to have capacity, one must be able to understand the relevant information to the decision. One must retain this information to permit a decision to be made. One must weigh up the risks and benefits of this decision. And one must be able to communicate a consistent decision, ideally over a period of time. Now, ultimately, in Australia, capacity is a legal definition and not purely a medical one, although medical personnel are often involved in making capacity assessments, like psychiatrists. So, if a patient lacks capacity, then decisions can be made by an enduring guardian, not necessarily the Mental Health Review Tribunal, like possibly occurs in India. If there's no enduring guardian, then the decision will go to the New South Wales Civil and Administrative Tribunals, that's NCAT, who can appoint a substitute guardian, such as a public guardian. And there are provisions to provide emergency treatment without consent if, under special circumstances. And those circumstances are if the treatment might save a patient's life, prevent them serious damage to their health or long-lasting physical damage. And it may prevent a patient from experiencing a significant amount of distress. Now, in Australia, this is governed, or in New South Wales, I should say, this is governed by the Guardianship Act, New South Wales, which is a 1987 Act, which is actually different from the Mental Health Act Civil 2007. So you can see that we do have capacity-based legislation. It just doesn't pertain directly to the treatment of mental illnesses and mental disorders. I think it's important to also understand that having a mental illness does not preclude one from providing consent or having the capacity to do so, even if the patient is in an active phase of their mental illness. Now, this may be different in India, where actually capacity-based assessments are required to treat someone involuntarily in the active phase of their mental illness. But in New South Wales, when it's a risk threshold system of providing involuntary care, it's less kind of relevant. So where does psychiatrists and capacity kind of intersect? Well, a psychiatrist might be asked to provide guidance on capacity where there is a nexus of symptoms of mental illness obfuscating decision making. For example, auditory hallucinations that tell a patient not to consent to surgery. Now, that's an obvious and dramatic one, but that's a circumstance where a psychiatrist might get involved. Because psychiatrists are experts on mental functioning and they can identify maybe the reasons why a patient might lack capacity, but importantly also how their treatment can be modified to restore capacity, because in New South Wales, in Australia, we operate on a recovery-oriented model of care as psychiatrists, and that's very important in restoring capacity. And again, we'll discuss this in fitness as well. And I should say that we take capacity very seriously in New South Wales, and it's a criminal offence to perform treatment on a patient without consent. And that's again defined in Part 5 of the Guardianship Act, New South Wales 1987. So in summary, psychiatrists are involved in capacity assessments, but the mental health legislation is not a capacity-based one in New South Wales, as it is in some other jurisdictions of the country.
So to follow up on that, Andrew, I would like to ask a real life scenario, like, if a patient XYZ comes to a hospital and the patient has significant persecutory delusions and auditory hallucinations, then how would we go about it? Suppose, say, for example, I am the psychiatrist working in New South Wales. So what do I do?
What you would do is you'd perform a comprehensive psychiatric assessment of the patient, and you would essentially assess the patient based on, a Maudsley formulation, but also assessing their risks. And if you felt that they needed an admission and that they felt that they didn't need an admission, and we know that anosognosia is inherent, or lack of insight is inherent to many mental illnesses, then what you might do is you might look at their risks of harm to self and others. You would look at whether the inpatient environment is the least restrictive form of safe and effective care. And if you felt that that was the case and the patient did not consent to treatment, and you felt that the risks of harm to both the patient and those around them were significant, then you would proceed with an involuntary admission to a mental health unit.
Yeah, so I think that made it very clear that how the legislation and regulatory framework in Australia, especially in New South Wales, is different from that in India, where we have to assess the capacity, and based on the decision-making capacity of the patient, we have to admit the patient under voluntary admission or the involuntary or the so-called supported admission. But there in New South Wales, it is different and it is a risk threshold based system. So if the person is a danger to others, is it just the dangers to others or is it also danger to self?
Danger to self and others. So we know that conditions such as, major depressive disorder, psychosis, psychotic spectrum conditions, and bipolar affective disorder have a far greater propensity towards victimize or vulnerability to patients, and harm to self as one of those vulnerabilities. And so an important part of mental health legislation respects harm for the patient to self, when assessing their risk threshold.
Yeah. So, say for example, if I'm the patient and I develop, I'm a patient of major depressive disorder, and if I develop suicidal ideation, so even if I am having the capacity to decide for myself that whether I should get admitted or not, but still, I think under the New South Wales regulatory framework, I would be, admitted against my will. Is that correct?
You could be admitted if the risks of harming yourself as a result of that major depressive disorder were significant enough, that inpatient care was considered the least restrictive form of safe and effective care. And we're quite lucky in Australia in that we do have a good network of community mental health services. Well, I speak for New South Wales, and we do have, a number of community mental health networks who can provide assertive outreach. And so escalating to involuntary inpatient care is not the only option, and should only really be invoked if that is the least restrictive form of safe and effective care. And that's called for by our Mental Health Act legislation in the civil jurisdiction.
And what would be the implications of that? Uh, do you have any movement or do you have any political discourse regarding the rights of the mentally ill patients? Because, the Mental Health Care Act 2017 here in India marks a transition from the older Mental Health Act of 1987, which was not a rights-based regulation, but Mental Health Care Act 2017 is a rights-based regulation. So, do you have such kind of discourse where some of the people or some sections of the society would feel that the rights of the mentally ill people are being violated?
Look, we had the state that's most analogous to New South Wales in certainly in Australia is Victoria, and Victoria moved towards a capacity-based or more capacity-based framework over the last few years, and we saw, like I said, that those other states, including Queensland, I think it was Western Australia. South Australia and Tasmania have moved that way. Certainly, there is discourse within mental health and legal reform in New South Wales towards a capacity-based legislation. I'm not privy to that discourse, but I understand that there's a movement towards globally towards capacity-based legislation. We've had our Mental Health Act since 2007. The most recent amendment was in 2025, to my understanding. But I'm not privy to discourse about, legislative reform. Um, but yes, I understand that there is some discourse in New South Wales regarding this.
Yes, and I would also like to ask that what is the role of judiciary in the involuntary or supported admission? Because, in India, I would like to say that most of the involuntary or supported admissions are being regulated by the law, but sometimes we have the court orders also for supported admissions. So, do you have the same thing there in Australia?
Yeah, look, when we discuss when we discuss the concept of kind of the Australian or what happens in Australian kind of forensic systems, we can cover kind of court ordered assessments and which are kind of covered in New South Wales legislation, but usually by the Mental Health and Cognitive Impairment Forensic Provisions Act rather than the Civil Act. We the majority of so as I said before, the Mental Health Review Tribunal here in New South Wales is the governing body that provides oversight to our Civil Mental Health Act as well as our Forensic Mental Health Act. And that's kind of our judiciary body that looks after, which is not actually a court, but it's a judiciary body that looks after the mental health legislation in New South Wales. The Mental Health Review Tribunal, should those decisions be appealed, is overseen in New South Wales by the Supreme Court, and that court is kind of the closest judiciary involvement, apart from court diversions, but that's a different matter, in the in the New South Wales jurisdiction. I think it's probably worth touching on just quickly the structure of the court system in New South Wales, because as we go in this discussion, we will talk about some of these courts, and I think it's probably having a look at how courts are structured in New South Wales. So look, the local court is the first court in New South Wales, and most cases begin here, civil and criminal. Um, we have a system of summary offences and indictable offences and strictly indictable offences in New South Wales. And those terms refer to summary offences as less serious offences, indictable offences as more serious offences, and strictly indictable offences that are the most serious offences. And they determine what court the offences are heard in. So the local court deals with civil claims up to about $100,000 and lower level summary offences. Serious offences start here, but are referred up the chain of courts, and no jury kind of is elected in the local court. Moving to the district court, that deals with more serious criminal trials like murder, treason, and terrorism and piracy are federal offences as well, are not dealt with in the local court. There are civil kind of claims from about $100,000 to about $1.25 million are heard in the district court, and there can be a judge only or jury trial here. The Supreme Court is a higher court in the state of New South Wales, and that's what I referenced when referencing the oversight to the Mental Health Review Tribunal. Murder trials are heard here most notably, and large civil claims. When there's kind of forensic psychiatric input in both the district and Supreme Courts. Then there's the Court of Appeal next, which is a civil court, the Court of Criminal Appeal, and then you've got the High Court of Australia, which is the final appellate court. And it's the unifying, it's really the unifying kind of court between the jurisdictions. And you're talking about the judiciary involvement of the Mental Health Care Act in India. Well, this is the unifying kind of court in that system, the High Court of Australia, and appeals through the Supreme Court would go up to the High Court of Australia. So that's kind of the unifying judiciary approach. But again, to circle back to your question about judiciary involvement in New South Wales, we have a quasi judicial administrative mental health review tribunal that caretakes the legislation in New South Wales rather than the involvement of the courts per se.
Yeah, so that was an excellent overview of the structure of judiciary that you gave in New South Wales. And if I have to draw the parallel between New South Wales and India, I would say that, the summary offenses and the indictable offenses that you mentioned here would be called the cognizable and non-cognizable offenses in India. And the only thing different would be that instead of the High Court of Australia, here we have the Supreme Court of India, and we have the High Court at each state level.
Okay, that's interesting. And do they have do they all have input into your mental health legislation as well?
Yes, so the courts are very, very powerful here in India, and if there's a court judgment I would guess that would override the Mental Health Care Act 2017. Mostly, it would be in the accordance with the law, but especially the high courts and the Supreme Courts have the power to override the legislation as well.
Okay, that's interesting. Certainly, the Mental Health Review Tribunal can be overridden by the Supreme Court, and the Supreme Court can be overridden by its higher courts. But first and foremost, it's the Mental Health Review Tribunal, which is adjacent to the court system that looks after the civil mental health legislation here in New South Wales. It's quite complex, but yeah.
Yeah, so that was quite fruitful. So now I think Dr. Bhavya can take on and ask a couple of questions on the next section.
Of course.
Yes, so Dr. Wilson, we touched upon assessment of general capacity before. So I would like to ask you that what are the protocols in the Australian legal framework for the assessment of testamentary capacity, that is the ability of the patient to make a will? So what would you comment on that?
It's interesting that you ask, Bhavya, because actually testamentary capacity, like you said, concerning wills, is actually more of the remit of a solicitor or a legal practitioner than it is a forensic psychiatrist. Just to kind of discuss, or a psychiatrist in general, just to discuss, though, testamentary capacity, a bit of history. Banks and Goodfellow, which is an 1870 case in the UK, in Victorian England, that's our precedent for testamentary capacity. Interestingly, it was John Banks was the testator in 1870, and he was suffering from delusions, believing that he was persecuted by a man who had been long dead, actually. And despite his delusions, Banks's will was actually held up in court, and it showed that mental illness does not immediately preclude testamentary capacity, and indeed it actually shows that mental illness does not automatically preclude more general concepts of capacity. So it's an important case in advocating for our patients, and I think it's an important one to understand as a psychiatrist, even if you tend to be adjacent to that process. Banks and Goodfellow has been confirmed and settled in New South Wales case law. If you look at, there was Timbry and Coffey in 1941, which went to the High Court, Bull and Fulton in 1942, that also went to the High Court, and Carr and Homersham, which is a notable recent case that went to the New South Wales Court of Appeal. Basically, Banks and Goodfellow stood up during those trials. The assessment of testamentary capacity, whilst it is the remit more of legal practitioners in Australia, I think it's important for psychiatrists to understand as well. And we understand it as an individual understanding the nature of making a will and its legal effects, understanding the extent of the property being disposed of, and understanding the claims of those who might benefit from the will itself. And an important part of the testamentary capacity assessment in New South Wales is ensuring that no mental disorder distorts judgment and influences the will. So whilst the legal practitioner is maybe the most adjacent to testamentary capacity, they still may ask for, a legal practitioner may ask for a report from a psychiatric or geriatric professional to bolster their assessment of testamentary capacity. And certainly it is the remit of a civil psychiatrist or civil psychogeriatrician or civil neuropsychologist to provide some of that guidance to legal practitioners, particularly when a more nuanced assessment is required. And as I said before, that psychiatrists are experts in mental functioning. So that's an important part, I think, in advocating for the testamentary capacity for patients, and also to providing the legal practitioner and the patient with an understanding of how to restore capacity through treatment as part of that advocacy and of that assessment. So yeah, that's testamentary capacity. It seems that it differs perhaps from India. Is that right?
I think it's pretty much in line with the Indian framework as well. So it's pretty much similar. So I would like to move on now to the criminal forensic psychiatry, and I would like to ask you that fitness to stand trial is a major question in India, and so I would like to ask you that what are the protocols in the Australian legal framework for determining the fitness to stand trial, and if a defendant is deemed unfit, then what happens to them, and what is the procedure further?
All right. Well, now this is more bread and butter kind of forensic psychiatry. So most things that we've talked about pertain to actually civil psychiatry. So fitness to stand trial is covered under Part 4 of the Mental Health and Cognitive Impairment Forensic Provisions Act 2020. Now, I've intentionally strayed away from specific sections and subsections of the Act so as not to put everyone in the audience asleep. But essentially, Part 4 discusses fitness to stand trial. Assessments of fitness, like I said, are the remit of forensic psychiatrists in the New South Wales jurisdiction. And Section 36 of that Act, the Forensic Provisions Act, we'll call it, because we'll be referring to it quite a lot now, quite frequently now during this kind of podcast. Well, that sets out the tests for fitness, which are based off the PRESA criteria. So R versus PRESA. It was a 1958 case. Very important case heard in the Supreme Court of Victoria. A 14-year-old boy, Edward John Presser, was charged with murder. He was alleged to have killed a playmate with an iron bar and concealed the body afterwards. And Edward Presser actually had an intellectual disability. Now, despite this intellectual disability, in my understanding of the case, he was found fit to stand trial and convicted of manslaughter. So the case provided a functional threshold for which to judge the capacity of individuals to stand fitness for trial. To be fit to stand trial. So tests of fitness, it should be said, to stand trial don't require individuals to understand complex rules of evidence, have a legal knowledge, or even make objectively sensible decisions. Rather, fitness is set out as understanding the offence, being able to plead to the charge, being able to exercise the right to challenge jurors, understanding generally the nature of the proceedings as an inquiry into the alleged offence, being able to follow the course of the court proceedings in a general manner, being able to understand the effects of evidence given against the accused, being able to mount a defence or provide an answer to their charge, being able to instruct legal counsel to mount a defence, and being able to communicate their own view of the facts as they relate to the offence. And also, as I said before, being able to decide on a defence that they will rely on and communicate that decision to their legal representative. So mental illness, again, like testamentary capacity, mental illness and cognitive impairment do not immediately preclude someone from being fit to stand trial. They're not the only things as well that might challenge fitness. For example, being hearing impaired, being visually impaired. Now, they also may challenge an individual's fitness to stand trial. And it's the remit of both the court and treating clinicians to improve capacity. I think another important case when considering fitness is Kesavaraja and the Queen and v. the Queen, and this is a 1994 case. Now, this gentleman was an Australian, and he was charged with offences in relation to the importation and trafficking of heroin. It's quite a serious crime in Australia, and the case was heard in Victoria and then in the High Court, which is that federal court we talked about before, on appeal. And Kesavaraja actually met the presser criteria that we discussed before. So he was fit to stand trial on his arraignment hearing. And an arraignment hearing in Australia is where the accused is brought before the court. They're formally told of their charges and they're asked to submit a plea, and he submitted not guilty. However, Kesavaraja, throughout the course of the trial, actually started to demonstrate features of psychosis. For example, he had delusions of grandeur. He believed that he was Lord Vishnu and that he was receiving messages from aliens. So the Kesavaraja case emphasized that fitness is not cross-sectional and can actually change and fluctuate throughout the course of a trial. He was fit on his arraignment. He became unfit. His fitness clearly deteriorated. And so ultimately, I think he was convicted of one of the offences and the other one was quashed. But what it did was instill in Australian psychiatry the importance of longitudinal assessments of fitness and an understanding that one's fitness can change throughout the trial. So to actually assess a patient for fitness or concerns regarding fitness, well, they're raised by anyone involved in the trial. And that's usually the prosecution, it could be the defence, it could be the court itself. And basically, these actors will refer to a forensic psychiatrist to submit reports based on fitness where these concerns are raised. I think it's important in a fitness assessment to reach a diagnosis to provide some sort of prognostication, because, and we're coming to the second part of your question, is how do we deal with individuals that are found unfit? So making a report on whether the patient will be found fit within 12 months is an important part of the fitness assessment in forensic psychiatry. And that basically provides a body of evidence to the judge. And if it's a jury trial, it's actually only the judge to determine whether a patient will be unfit to stand trial on the balance of probabilities. So if the accused is found unfit, they're going to be referred to the Mental Health Review Tribunal. If they're reassessed and they're found fit later on, then they are returned to trial. If it's unlikely that they will be fit within 12 months for trial, then they are referred to a special hearing. And here is where the New South Wales jurisdiction becomes a little bit complicated, and I'd be interested to know how this compares to India. So special hearing is not an ordinary criminal trial, and it deals with patients that are unfit, as we said, to stand trial. It can be modified to improve the accused's engagement in the court proceedings. Generally, in the special hearing, the accused has to be represented generally by a legal practitioner unless the court decides otherwise. And that's because of their presumed difficulties with capacity. Usually it's a judge-only trial, although a jury can be present. And despite being unfit, though, which is important, the defendant can give evidence to the court and they can challenge a jury if one is elected. Limited evidence in these special hearings is actually taken into account, but the usual criminal standard of beyond reasonable doubt is still used. You can be guilty, you can be not guilty, or you could be act proven but not criminally responsible as the verdicts of special hearings, and we'll discuss that in a second. If found guilty at a special hearing, then a concept called a limiting term, which I think is unique to the New South Wales jurisdiction in Australia, can be imposed. And what that is, it's an estimation of the sentence of an individual should they have gone to a normal trial, so not a special hearing. And it converts that sentence into a non-conviction recorded period of being a forensic patient, essentially. And the reason why an estimation of the original sentence is used, it actually prevents patients from being kind of over-securitized or made a forensic patient and subject to forensic orders for a greater period of time than the sentence that they would have served had they been found fit and had they been found guilty of their crime. So fitness is quite complex in Australia. I'd be interested to know whether India has a similar system to the Kesavaraja and the Presa criteria. They are certainly bread and butter for forensic psychiatrists in the court divisions.
Yeah, so that was quite a comprehensive overview of the assessment of fitness to stand trial. I would like to draw similarities from what you told, that the fitness is a longitudinal assessment.
Yep.
So that draws parallel with the Indian system as well, that the fitness can change over the period of time. Patient can become unfit. So that has to be a longitudinal assessment. And yeah, so that was a quite a bit of comprehensive overview of the fitness to stand trial. And now I would like to move forward with Dr. Divyam asking the questions.
Yeah, so I would like to point, Dr. Andrew, that we have a lot of similarities in Indian and Australian system because of one thing that we have in common from our past, and that is the British foundations. But
That's right.
but we also do have certain differences, and one such difference that I think you alluded to, that was the special hearing. So I don't think we have anything like special hearing here in India, and
Okay.
we don't even have the limiting term.
So might I ask, in India, if an individual is found recurrently unfit to stand trial, then what are the options regarding progressing their hearing?
The hearing would not progress, and the person would be sent to some hospital for mental health. So the person would be under psychiatric care, the long-term psychiatric care, until the patient regains the fitness to stand trial.
I guess in the reason why, my understanding of the reason why the New South Wales jurisdiction draws a limit of 12 months on fitness versus unfitness and then sends a patient to a special hearing is to prevent patients from being found recurrently unfit. Now, some of these patients might be, because of their risks, might be detained in correctional centres awaiting their trial. And so it essentially stops the possibility that they would be involuntarily detained forever by forcing a judgment, by forcing an outcome of the criminal proceedings. To provide them some, finality in the end to their hearing, to force a hearing to take place essentially. Because if you're found recurrently unfit, then it's very difficult for you to actually ever exit the criminal justice system, particularly if you're not granted bail and you're remanded in a correctional centre for that period of time.
Yeah. And also, I would like to draw the parallels in the testamentary capacity that you alluded to, Banks versus Goodfellow. So I think that is exactly the judgment which also is the basis or the foundation of the testamentary capacity law here in India as well. So that is quite similar to Australia, what we have here in India.
And tell me, Divyam, is it the remit of solicitors as well to be assessing capacity, particularly testamentary capacity, in India?
No, that is different. There is a greater involvement of psychiatrists and mental health care system for assessment of the testamentary capacity. I don't think that solicitors or advocates would have that power to assess the capacity.
Okay, that's very interesting.
Yeah.
So when a will is made in India, you've piqued my curiosity. When a will is made in India, then is a psychiatrist automatically involved, or is it only if there are concerns about testamentary capacity raised by a legal professional?
Only if there are concerns raised by some party who is, somebody who is a party to the will. If there are concerns raised by them, then only there is an involvement of psychiatrist and mental health care system. And as you told earlier, that the capacity is generally presumed by the legal system. So most of the bills, if they are not challenged, the bill would go through.
That's very interesting, and yeah, it's. I think it's interesting to see the different points at which people actually enter the system to have per se to have a psychiatric to access psychiatric assessment. And it's interesting that Australia it actually comes through the legal pathway, whereas in India it seems to come through possibly a family member or a psychosocial network advocacy pathway, which is a major difference between the two jurisdictions.
Yes. Now, moving forward, Andrew, I would like to ask you about the insanity defense, because here it is a big thing in India, and a lot of people who are charged with some of the serious crimes, what you would in Australia call the highly indictable crimes, they would
Notable,
use
yeah.
yeah, they would use the insanity defense that at the time of committing the crime, the person was not having the capacity to make right from wrong or legal from illegal. So, what's the case there in Australia?
So, like India, we had a colonial past, and Britain somewhat anchors the foundation of the mental health defence. And what I mean by that is that the mental health defence in Australia relies on M'Naughton's rules. And M'Naughton, and again, a history lesson, but I feel like understanding the history of these cases actually allows you to understand them a little bit better rather than purely memorizing. And the M'Naughton case is an interesting case. So the M'Naughton case on which our mental health defence is based is an 1843 case, and it involved the acquittal of Daniel M'Naughton in England for the murder of Edward Drummond. Now, Daniel M'Naughton was actually a Scottish wood turner. So he would turn wood on a lathe, he would carve things, and he was from Glasgow, and he travelled all the way to London to shoot someone, a member of the Tory party. Now, he shot the wrong man. He shot Edwin Drummond with a pistol on the 20th of January 1843, but who he meant to shoot was the Tory Prime Minister at the time, who was Robert Peel. Now, M'Naughton was suffering persecutory and paranoid delusions at the time, I think within a schizophrenia spectrum illness, and he believed that the Tory party were tracking him and following him, even back in Glasgow in Scotland. Now, M'Naughton was found to be insane at the time of his crime and was acquitted of his offence. And that is a real landmark in forensic mental health defence or mental health defence. And what the House of Lords then defined the defence of insanity along the following lines, that individuals do not understand that the nature and quality of their act was they do not understand the nature and quality of the act, full stop. They do not understand that the act was wrong, and that the accused was suffering a disease of the mind at the time of the act. Now, in modern terms, that means really whether the defendant knew that the act was wrong is kind of defined as the ability to act in a moderate degree of sense and composure about whether the act was perceived as wrong by kind of a reasonable number of members of the public, right? Disease of the mind, similarly, is a term or group of terms that has been replaced, at least in the New South Wales jurisdiction, with mental health impairment and cognitive impairment. And we talked about these before because they're in the title of our Forensic Mental Health Act. So in Australia, the mental health defence comes through the patient's legal representative. So a legal representative in New South Wales might request a psychiatric assessment from a forensic psychiatrist as part of their mental health defence. And generally, the legal representative will have sat down with the patient and spoken about which defence they would like to pursue. So the forensic psychiatrist, as part of this assessment, should assess whether the defendant had a mental or cognitive impairment as defined by the Forensic Provisions Act that we talked about before, at the time of the alleged offence, and we actually discussed the definitions of mental health impairment and cognitive impairment as well before. So whether the defendant knew that the nature or quality of the act or could reason about its wrongness. So that's the second thing to assess. And then the third thing, if these are not the case, they didn't know about the nature of the quality of the act, or they didn't know that it was wrong, what features of the impairment, be that the mental health impairment or the cognitive impairment, are actually responsible for producing this? So in New South Wales, the verdict is called Act Proven and Not Criminally Responsible. So that's APNCR. It's the new name for the old verdict, which was Not Guilty by Reason of Mental Illness, or NGMI. It's called various names through the different jurisdictions in Australia, but every jurisdiction in Australia has the right to a mental health defence. If a verdict of APNCR is returned in New South Wales, then the patient is an involuntary forensic patient, and they're referred to the Forensic Division of the Mental Health Review Tribunal for oversight. So the court that makes the decision about the APNCR verdict, usually the Supreme Court of New South Wales, they cannot actually release the patient themselves. Only the Mental Health Review Tribunal can. So essentially from here, from the verdict of Act Proven and Not Criminally Responsible, the patient enters the forensic system and they can only be released on a further decision by the Mental Health Review Tribunal. And very often patients spend a number of years in the forensic mental health system, which is a recovery-oriented rehabilitative system that prepares patients to reintegrate back into the community and ensures both the safety of the patient, but also the broader community. And these are safety concerns, like in the civil mental health legislation. Safety concerns are a major driving force of forensic mental health rehabilitation.
Yeah, so you referred to the Mental Health Review Tribunal. So can you tell us that what does it consist of? Is it just a psychiatric body, or is it a quasi-judicial body?
Quasi-judicial body, Divyam, and so it aims to have a balanced perspective on things. So it aims to have a medical opinion, which is in the form of a psychiatrist. It aims to have a judicial opinion, which is the preside, which is a legal representative, usually a judge, a magistrate. And then it aims to have a allied health perspective. So very often there'll be a social worker that sits on the panel, or an occupational therapist. And even particularly with the civil division of the Mental Health Review Tribunal, there could be a member of the community on the panel. These are open hearings, and they're also attended in the forensic system by the Special Victim Support Service, who advocate for victims of index offences of patients. They're attended by the patient themselves. They're attended by advocates for the patient. So that could be family members, it could be a guardian, and they're attended by the team who are charged with the care of looking after the patient, so the treating team. And if I'm the registrar, for example, that would be me. I submit a report to the Mental Health Review Tribunal. I provide them with a plan of what I'm looking to achieve. So are we looking to continue the provisions of the current order? Are we looking to release the patient? Are we looking to continue their detention? Are we looking to vary the order and vary the conditions of the order? And essentially, the Mental Health Review Tribunal in New South Wales convenes a hearing, reviews the available information, and then provides an outcome.
Yeah, so I think that is different from what we have here in India, that mostly the patient would be referred to a psychiatrist, or the psychiatrist would be called in court as an expert witness to give his or her opinion about the capacity, or if the person is, or if the prosecution is taking the insanity defense, then the judge would consult a psychiatrist, but a psychiatrist would not be the part of the decision-making body like you have there in New South Wales.
I should clarify that when it comes to the When it comes to the verdict of APNCR, that is a judicial decision that is
Okay.
made in the court system. Yeah, it's only after a patient becomes a forensic patient that the Mental Health Review Tribunal gets involved.
Okay. So,
Yes,
so the decision remains a judicial decision.
absolutely, that's right. And like in India, and like in the UK, that expert witnesses, usually forensic psychiatrists, are called to give evidence, with respect to McNaughton's rules, to determine the availability of an insanity defence or mental health defence, as we call it now. So I think we're quite similar.
Yeah. So here in India also the system is based on the McNaughton's rule with some changes. I think that is quite different with the United States, where they also include irresistible impulse as a defense. But here in India, we don't. We only treat the unsoundness of mind as a defense and not the irresistible impulse. So a person cannot take the defense of an irresistible impulse. Like if the person has impulse control disorder, then he or she would not be able to defend himself or herself in the court of law. But I think that is different in the United States.
That's very interesting, and it lends the it appears to me it might lend defences, mental health defences, to impulse control regulation conditions like neurodivergent conditions, attention deficit hyperactivity disorder, even some personality disorders that are associated with increased impulsivity. Again, like you said, our anchor of Britain between England and India means that we take a McNaughton's approach to the mental health defence, which is very different from, it seems, the United States, actually. Although I should say that what is being classified as a mental health impairment is potentially broadening in Australia, well, in the New South Wales jurisdiction. Yeah, look, it's very interesting to see the differences between the different countries.
Yeah, and one of the mental health disorder where we would see this is the manic phase of bipolar disorder. So in the manic phase, if the person doesn't have psychotic features, and if the person commits some crime, then he would not be able to take the defense because that is just because of the impulsivity. And only if the person has psychotic symptoms, then he or she would be able to take the insanity defense here in India.
Okay, that's very interesting.
Yeah. Lastly, I would also like to ask you that, we talked about the Mental Health Care Act 2017 here in India and the Forensic Provisions Act there 2020 there in Australia. So you said that it includes mental illness and cognitive impairment. So here in India,
Yeah.
the Mental Health Care Act 2017 does not include or excludes intellectual disability. So what is the status there in Australia?
Well, in New South Wales, where I can speak to, and I know that this is the case with other states, intellectual disability, of which there is a high prevalence amongst the both incarcerated patient population, but also the forensic mental health patient population, often as a comorbidity, but sometimes as a standalone sentinel pathology. That is considered a cognitive impairment under the Mental Health and Cognitive Impairment Forensic Provisions Act, and therefore can be taken into account when considering patients as forensic patients.
Yeah, so that is again different from what we have here in India, that we don't consider intellectual disability in the purview of Mental Health Care Act 2017, and it comes under another act called Rights of Persons with Disability 2016. So mostly, whatever the provisions are there in Mental Health Care Act 2017 would not apply to intellectual disability, but would apply to major neurocognitive disorder where there is cognitive impairment not developing in the developmental years of a person.
Okay, that's very interesting.
Yes. So, Andrew, that was a wonderful webinar, and let me tell you that you outlined, regarding the regulatory frameworks, the insanity defense, the testamentary capacity, the the criminal defenses that you can take. So everything you outlined quite well, and this session is being recorded and will be uploaded on YouTube. So for anybody who is interested in forensic psychiatry and forensic psychiatry comparisons across India and Australia would be able to see this for many, many years to come.
That's wonderful. It's been a great discussion. I'm really passionate about speaking about psychiatry and certainly forensic psychiatry. And it is so interesting to see how our shared colonial history actually, in some ways, roots the Australian and Indian jurisdictions in some commonalities, but still that there are major differences, including capacity-based mental health legislation in India that the New South Wales jurisdiction, at least, has not essentially taken. So I found it very interesting, and I really thank you and Dr. Bhavya for having me on this discussion. It's been a wonderful way to spend my Sunday, and I'm so glad that I was given the opportunity to speak to both of you and possibly to influence other discussions about forensic psychiatry, both in India and in Australia.
Yeah, so I think before the session started, you and Bhavya were talking about the DiGo Talks community. So I would like to briefly say something about the DiGo Talks community. So I started this community in 2023 when I first released my book on longevity, because at that time I was into longevity and I was not into psychiatry. And today we have about more than 500 physicians, mostly physicians, but also health enthusiasts and longevity enthusiasts from about 17 countries across the globe in the DiGo Talks community. And, I would like to invite you as well as other members in the audience to join the community. So it's, nothing's, you don't have to contribute actively in that. You can be a passive member of it and just be there. And at your time, you can contribute to the community.
I thought that some of the talks that I saw on the YouTube page and some of the videos that I saw on the Instagram page were very interesting. I was looking at them ahead of our interview today, and I think it's wonderful that you've put together a free resource, a public resource that covers so many different topics, and I'm really privileged to be a part of that now.
Yeah. So any last comments from Bhavya? Do you want to say anything, Bhavya?
Yeah, it was quite an insightful session. We got to know so much about the Australian legal framework as well, and we got to compare and contrast it with the Indian framework. I mean, that was quite insightful, and it was fun talking to you, Andrew.
It was lovely to speak to you too, Bhavya.
Thanks. Bye bye.
Thank you. Thank you, Andrew.
Thank you very much, Divyam. Thank you.
Bye bye.
Bye.